The Federal High Court in Abuja has adjourned the ongoing trial against the leader of the proscribed Indigenous People of Biafra, IPOB, Nnamdi Kanu, to September 23rd, 25th, and 26th, 2024, following the inability of the trial to commence properly. Justice Binta Nyako made the adjournment after the defense counsels prayed the court to explore Section 17 of the Federal High Court Act on following the denial of his application to quash the remaining 7-count charge against Kanu. Section 17 of the Federal High Court Act states that in any proceedings in the court may promote reconciliation among the parties thereto and encourage and facilitate the amicable settlement thereof. This was the submission of Nnamdi Kanu lawyer Ejimako before Justice Binta Nyako following the dismissal of a fresh application by Kanu challenging the jurisdiction of the court to entertain count 1, 2, 3, 4, 5, 8, and 15 of being unconstitutional. The court held that it cannot overrule itself on issues it had already resolved, adding that the only option left for the applicant was to proceed on appeal. At the proceeding, Ejimako noted that trial cannot go on if his client's right to fair hearing is being questioned. Ejimako also brought to the attention of the court that the Department of State Services (DSS) was yet to comply with the order of the court as their visit to Kanu was being barged. He, however, stated that the defendant has resolved to contempt of court proceedings against the Director General of the DSS for refusing to obey the court orders, directing the service to grant Kanu a safe room on bugged space for meeting with his lawyers. In response on the issue of the Section 17 on the High Court Act 2011, the prosecution lawyer Adeboyega Awomolo San informed the court that he does not have the instruction of his client to win back on any negations with the defendant over the charge. Awomolo noted that he held Ejimako to go to the Attorney General of the Federation (AGF), who has the power. However, trial judge who said that the court has no problem if the parties want to discuss negotiation, urged Kanu to approach the AGF, also who is the proper person to negotiate with, on the issue of Forms 48 and 49, seeking the imprisonment of the DSS boss for allegedly disobeying the court order. Justice Nyako held that both applications were not before her, adding that the matter would be looked into when she sees the file. Nyako, however, ordered the service to provide an unbugged space for Kanu to meet his lawyers each time they were at the facility to prepare Kanu for trial.
What you heard in court about Section 17 of the Federal High Court Act is simply what the National Assembly enacted. The National Assembly enacted at that Section 17 that reconciliation shall be promoted by the court between parties before the court, criminal or civil. So it so happened, and it came to pass that today that very issue was briefly considered in open court. So it is either for the court in its wisdom to initiate it and direct that parties do go and engage in such conversation, which the court did indirectly by not opposing it and by even suggesting it, or the parties themselves, either party, either the defendant or the prosecution, can initiate it. So that's not very unusual. Recently we saw a situation where the Attorney General of the Federation took steps under Section 174 of the Constitution, which is very similar to Section 17 of the Federal High Court Act. He took that position to discontinue the prosecution of two very high-profile cases in this country. The first one concerning Wole, Yele, Showore, and the second one concerning Bodijo of Mieteala. So these things are not unusual. So if they do occur as a conversation in open court, it's just as a matter of course. So people might wonder why such situation should not apply to Nnamdi Kanu, and that is what played out in court today.
Reporting from Nigeria's state capital, Soweto, Jackridge, Top Accolade News.